obviously being in prison, no longer being in a position of power, no longer having access to the instruments of power, the former president has absolutely no means to commit crimes. Not that he ever committed crimes, because we believe that he was innocent anyway. But regarding the risk of flight, well, he's 80 years old. He's tired. He's not going anywhere. He's probably one of the most famous people on the planet. It would be impossible for him to flee and for him to hide anywhere. And as for the risk of threatening witnesses, well, we have strong grounds to argue that that would never take place anyway. And let's face it, there have been Senate hearings where people have come, they've made these allegations in the past against the former president, and absolutely nothing has happened to them. So there's no concrete risk whatsoever of a threat to witnesses. All the risk factors that exist can be adequately neutralized.
Alright, magandang araw po sa inyo lahat. Muli po tayo nagbabalik sa napakagandang reaction video. Ako po si Opinion and Reaction PH. Panoorin at reaksyonan po natin itong full interview kay Atty. Kaufman. Pero bago po tayo magpatuloy sa ating reaction video, huwag niyo naman po kalimutan pindutin ang like, share, at subscribe.
Duterte at the International Criminal Court. Good day, sir, and welcome to ABS-CBN News.
Good day, and thank you for having me, RG.
Sir, in September, President Duterte will be facing a confirmation of charges hearing. So for those who are not in the know, what happens in a confirmation of charges hearing? What can we expect?
Well, the confirmation of charges hearing is basically the second stage in the criminal process of the International Criminal Court. The first stage is the part of the process where the defense really has no role. That's the issuance of an arrest warrant. And an arrest warrant is issued on the basis of a reasonable suspicion, namely that the judges have reasonable grounds to believe that the suspect, in this case the former president, committed a criminal offence. The second stage of the criminal process is after disclosure has taken place. That is, disclosure of the prosecution's evidence. And then the judges examine the evidence to see whether or not substantial grounds are made out to believe that the former president committed the crimes that he's accused of. And then obviously the third stage of the process, if we get beyond the confirmation of charges, which is when the judges examine the substantial grounds to believe, the third stage of the process is the trial. And we all know that you can only be convicted at the criminal court, International Criminal Court, if beyond a reasonable doubt, if there's evidence to show that crimes have been committed beyond a reasonable doubt. So really we are at the middle stage of the process now. We've been disclosed the prosecution's evidence and we're beginning to learn it. As I said, it's a lot of evidence. Something like 2,000 items of evidence, even more. And each item of evidence contains up to 100 pages of evidence. So there's a huge amount of work. We approach this exercise using information technology. The court has its own systems. We're all experienced in managing databases. We have to be in order to assess the evidence and to analyze it and to be able to counter it at the confirmation of charges proceedings.
Okay, sir, you talked about the disclosure of evidence, and you talked about the voluminous evidence that you've received. So, are these all just documentary evidence? Can you give us an idea? Are these documentary? Are these testimonies? How many witnesses or non-documentary evidence did you receive during the disclosure?
Well, the evidence falls broadly into two categories. You have documentary evidence, open source media evidence. Basically, that would be the speeches that the former president gave, which the prosecution are relying on. And then there's the evidence which is derived from witnesses. Now, there are two forms of witnesses, two principal forms of witnesses. You have witnesses who are family members of victims or alleged victims. I say alleged victims because it's the prosecution who has to prove whether or not crimes were committed, not the defense to disprove. And then the second, obviously, category of documentary evidence or testimonial evidence would be that deriving from former, let's say, hitmen, people who allegedly carried out the extrajudicial killings.
Sir, how are you preparing for this? obviously there's a lot of work that is involved. So can you give us an idea of what kind of preparations are you are you, aside from going through the evidence, are you allowed to cross-examine any of the witnesses at this point?
Definitely not, no, because the prosecution will not be bringing any witnesses. They've already declared that. They're not bringing any witnesses at confirmation. And from a defense perspective, it would be a mistake to present witnesses at confirmation in order to challenge the prosecution's evidence, for the simple reason that you wouldn't want to disclose your cards so early on in the game. Obviously, if charges are confirmed, you would want to maintain an element of surprise. As I've already said, it's not for the defense to disprove charges, it's for the prosecution to prove the charges. We call that the evidentiary burden.
Okay. If you talked about this process being a matter of stages, and we are now in the middle stage. So if this proceeding gets past the confirmation of charges, then it goes to a full-blown trial. Is it correct to understand that there's a possibility that at this point the case could still be dismissed?
Yes, there is a possibility. As I said, the test is, are there substantial grounds to believe that the former president committed the crimes which he's accused of? That is a lower standard than the standard at trial, which is beyond a reasonable doubt. So, on the basis of the evidence that we've had to disclose to us, we can argue that various crucial elements of the crimes have not been made out on the substantial grounds standard and ask for the case to be dismissed. And that's what we would attempt to do.
Okay. Mr. Duterte has been in detention for 5 months. So how confident are you of the prospects of this case not going beyond this stage that we are about to enter?
Well, I'm very cautious about talking prospects. I know that my team and I have done the best we possibly can, and we're hoping for the best possible result. And obviously the best possible result would be that this case would not go beyond the confirmation stage of proceedings. However, we're up against a prosecution. We're up against a strong prosecution, I may say, which has been investigating this case for the best part of 5 years. They've accumulated a huge amount of evidence. So to a certain degree, they have an advantage on the defense. That doesn't mean that the defense is not able to analyze the evidence which has been disclosed with a fine-tooth comb and find, shall we say, loopholes or mistakes or things that haven't been properly investigated. That's our job. We're there to make sure that if the charges are confirmed, they're confirmed for the right reasons and not for the wrong reasons.
Sir, there were also reports about the possibility of an interim release for the former president. First of all, what happens in an interim release? Is it like this is a concept that is entirely new to the Philippine audience, because I don't think we have that in our system. So what happens first in an interim release generally?
Well, it's called interim release because it means you're released until trial or released until the judges should decide otherwise. It's a right of every suspect to be released because every suspect, until proven guilty, is in fact innocent. However, on the basis of the reasonable grounds standard, there are certain factors which the judges of the court will argue militate against interim release, and there are 3 recognized risk factors. Those factors are, first of all, the risk of flight, secondly, the risk of interference with witnesses and evidence, and thirdly, the risk of continuing to commit crimes. Okay, now obviously, being in prison, no longer being in a position of power, no longer having access to the instruments of power, the former president has absolutely no means to commit crimes. Not that he ever committed crimes, because we believe that he was innocent anyway. But regarding the risk of flight, well, he's 80 years old. He's tired. He's not going anywhere. He's probably one of the most famous people on the planet. It would be impossible for him to flee and for him to hide anywhere. And as for the risk of threatening witnesses, well, we have strong grounds to argue that that would never take place anyway. And let's face it, there have been Senate hearings where people have come. They've made these allegations in the past against the former president, and absolutely nothing has happened to them. So there's no concrete risk whatsoever of a threat to witnesses. All the risk factors that exist can be adequately neutralized. However, that's not the end of the story. In order for someone to be released at the International Criminal Court, there is a need for a host state to receive him. And we have undergone negotiations. We had an agreement with the prosecution for one state. That was frustrated for reasons which will become apparent in due course. We have another state which is currently contemplated by the court and by the prosecution. The prosecution object, and it's for the judges to decide. Unfortunately, I'm not at liberty to mention names of countries for the simple reason that the matter is subject to confidential litigation.
Okay, just to clarify, and I guess to manage the expectations of everybody who is or members of the public who are interested in this case, in an interim release, does he or is he allowed to come back to the Philippines?
Well, he would be able to come back to the Philippines if the Philippines were amenable to receive him. The prosecution would probably object, and they would object because they would say that some of their witnesses, presumably, are in the Philippines, or some of the victims' families are still in the Philippines, so they would vehemently object. So would the victims object, and the victims, unfortunately, have a exaggerated role sometimes in the process. That doesn't mean that they shouldn't have a role in the process. Of course, they should have the right to say what they believe and express their concerns, but they shouldn't dictate the course of the proceedings. That is for the prosecution and the defense. However, yes, he has a right to return to the Philippines, and I ideally wish he would return to the Philippines. In fact, if the current authorities in the Philippines were amenable to that, I would be on the first plane out and willing to discuss it with them.
So just to clarify again, so the Philippines is a possibility, or theoretically just a possibility, or is it an active option for you?
Well, I'm not going to talk about active options or non-active options, because that would basically be entering into a territory which I'm not allowed to enter into, pursuant to the dictates of the judges. As I said, interim release applications and the receiving states are, as a rule, confidential. So I'm not going to comment one way or the other. I'm just saying that the possibility, theoretical or not, exists for someone to be interim released to the country from where he comes and from where the crimes allegedly were committed. As I said, allegedly were committed.
So it's I guess what I'm trying to establish is the Philippines is not disqualified on any ground as a possibility for interim release, so long as the Philippine government agrees to it.
Correct, and so long as the prosecution and the judges agree to it.
Yes, of course.
Not just us who decide. Yes.
Okay. I've been reading up on cases that are pending before the International Criminal Court, and a lot of these cases really drag on for years. So, how do you have an estimate of how long this process could go in case it goes to a full-blown trial?
If it goes to a full-blown trial, unfortunately, yes, it will take a long time, and I don't want it to go there to get to that point. I certainly do not want it to get to the stage where we have to run a trial. And I have good grounds to believe that that will not take place, but I'm not going to elaborate now. Now, I do want to touch on, because everybody realizes that we've asked presently to suspend interim release. And the reason for that is because we're entitled to receive all information relevant to argue our case. And we've been arguing for more than a month. This has been the subject of litigation, and you will have seen it in the public filings. We've been arguing for more than a month for access to information which is crucial, essential for our interim release application. And we don't want to make a half-hearted application for interim release. The first request for interim release is always the most important. And we've been denied crucial information that we need in order to succeed in our request for interim release. And let me add something else. If you've been following the court, you will know that in what are called atrocity crimes, which is basically Article 5 crimes, crimes against humanity or war crimes, people are never released at the International Criminal Court. The fact that we've got this far with a prosecution agreement to at least one state, which has now been frustrated, as I mentioned, is a feat in itself. And we hope to follow that through. We have good reasons to follow it through, and we hope that the judges will accept our arguments on interim release.
And thank you for bringing up that point, actually, sir. I was about to ask that because when the news broke that you asked, or that the defense asked to delay a decision on the interim release bid, people were caught by surprise because we all thought that a decision was forthcoming.
Well, no, not at the moment. As I said, there is essential information which unfortunately I cannot disclose to the general public. I wish I could, but I can't because I would be offending the rules and regulations of the court. But this information, trust me, it's essential.
But and you've already obtained that information, and it's already being you're already about to make your arguments. I would like to.
We have received some of the information which increases our belief in the correct nature of our argument and the need for this information. There are still further procedures that need to be done and further information that needs to be received in order to complete the process. I know it sounds very cryptic, but trust me, we need this information. We're doing our utmost.
Is the matter of interim release something that has to be decided before the confirmation of charges, or is it something that can run parallel with that process?
It can run parallel. It can be decided at any time, and it might become even a stronger argument after the confirmation process if certain charges are not confirmed. Let me give an example. In the Bemba case, the judges heard the arguments of confirmation, changed the mode of liability from one of active participation or perpetration by the suspect to one of command responsibility. And as a result of that, Mr. Bemba was released, or at least there was an order that he be released, which unfortunately was overturned on appeal.
I see. That's all our questions for now. Attorney Kaufman, thank you for this interview and thank you for talking to us.
Yun po ng mga kababayan, nadinig niyo po itong interview ni Atty. Kaufman na hindi po namamatay yung pag pananalangin na makalabas kahit sa interim release lang ito si Pangulong Rodrigo Duterte. O well, mga kababayan, hanggang dito na lamang po ang ating reaction video. Lagi po kayong mag-iingat at God bless. Duterte po tayo hanggang dulo.